essential workers or qualified immigrants in the budget reconciliation bill which they have been proposing. We're going to discuss about the immigration consequences of being arrested. We are going to discuss about the updates on the travel ban, and also the US Congressman is telling that about 200,000 people in the employment-based immigration will die before they get the green card. It so happens that most of them will happen to be Indian nationals, according to him. We're going to discuss about that. Emily, in the budget bill, it's not clear that they're going to include the employment-based immigrants or not. But in the Congress, in the House of Representatives, they used a different word. When it comes to the Senate, they use a different word. But the words essentially are essential workers. That's the word used in the House of Representatives. And when it comes to the Senate, they use the word called qualified immigrants. They didn't define it. By September 15th, we're going to have all the description. What do you think about the employment-based immigration, EB1, EB2, EB3? Will they be considered as essential workers or qualified immigrants?
It's so hard to tell right now. I think that there's a chance that some portions of employment-based could be included, particularly as qualified immigrants. I could see age-out kids being considered qualified immigrants. As essential workers, generally, that when the House uses that term, I think they're not referring to employment-based immigration, the legal system. But it's up to our audience to advocate for these things. We have a group of, 37 representatives in Congress sent a letter in support of including employment-based immigration reforms, getting this backlog fixed as part of the budget reconciliation process. So is it currently expected that essential workers or qualified immigrants will include employment-based immigrants? We don't know, but how do we make sure it is? We need to advocate for that.
So the congressman wrote letter to the Nancy Pelosi and the Chuck Schumer, the majority leader in the Senate. But what about our guys? If they want to draft a letter and send it, is there any drafts that we have provided for them?
Yes, we do have a template for you at rnlawgroup.com. I'm sure we have the link.
It's there in the provided
included here for you. Please contact your representative, contact your senator. Make sure that you let them know that if there is immigration reform included in this budget reconciliation process, that dealing with the backlog has to be part of it. It just doesn't make sense to create all these pathways for other people and assume that, well, legal immigration, there is a pathway, so we don't need to do anything. When that pathway requires 200,000 people to die before they ever get the green card, that's not a real pathway to citizenship or permanent residence. So please, you need to do your effort. Make sure to contact your representative, your senator, have your friends do it, have your family do it. Because you need to make your voice heard and make sure this gets included. This is a very short window that we have, window of opportunity to advocate for yourself.
Emily, 200,000 people are going to die. Mostly it happens to be Indians while they're waiting in the line for the green card. And now we know that the US CIS is wasting the green cards. For the people who don't want these wastage of green cards, there are still some steps that the USCIS can do to save the green cards. According to the declaration that they submitted to the court, seems that approximately around 80,000 green cards will be wasted. We don't know how many more next year will be wasted. There are still ways where they can still save. We still have about 25 days to approve more green cards. Even if they cannot, there's still other ways of allowing these numbers to float to the next year so we can handle them next year. What is the provisions that we can do where we can save the rest of the 80,000 green cards, Emily?
Yeah, I think one of them is more difficult and one may be slightly easier. The difficult one would be to get Congress to act, because Congress set up this system of how family-based spills over to employment-based, and technically employment-based that go unused spill over to family-based in the following year. So they do keep going back and forth, but the amount of spillover that goes to the family-based is capped based on how many immediate relatives and permanent residents were granted their permanent residence in the prior year. So basically the spillover to family doesn't actually happen. So Congress would have to change the law or create a new law that would stop that spillover from happening due to extraordinary circumstances like the COVID-19 pandemic that USCIS likes to blame all of this on. Is Congress working towards that? It doesn't seem like it, but that's one option. One other option would be to use the law as it already exists and have USCIS approve those green cards that happen to be pending on September 30th, where the final action date is current, and then they can turn around and revoke them on October 1st if they find that they have to complete the adjudication process. When they do that, those revoked green cards go back into the pool and can be used so that they don't go to waste.
So for the people, ordinary people, this is a little bit more complex, Emily. Is there any provision where they can write a letter, to whom they can write a letter? Because we know that Congress is busy in a lot of different things. When we contact the congressman, they say, okay, we are working on this major bill. That's a response that we get. But is there any draft of the letter of the complicated legal issue that you have pointed out right now?
Yes, we do have a draft letter for you on that as well. And this is directed to the USCIS Ombudsman office because it has to be done by USCIS, this option, and Congress is too busy. They're not going to take the time to urge USCIS to do this. So we're hoping that if we reach out to the Ombudsman office, they will see that this is going to be a way forward so that we don't end up wasting these green cards. And we do have that template as well.
Yes, please. I urge all the people to save the green cards so that we can avoid some of the 200,000 people that are going to die while waiting for the green card. This is not what I said. This is Congressman from Illinois who said that, which we agree. I mean, based on how the things are going on, if nothing goes on, that's going to happen. 200,000 people are going to die, mostly Indians. Maybe some part of the Chinese nationals will die too. So please, there are two letters. One, to have the employment-based immigration to be included in the budget reconciliation bill. The second one is to not allow the wastage of the green cards that are going on right now. So please, if you have not written the letter, we urge you to write these letters. Look at the lobbying efforts, how the Dreamers are doing. Look at the lobbying efforts, how the farm workers are doing. Look at the lobbying efforts, how the other visa categories are doing. We are not doing enough lobbying. All we need to do is a write letter. You don't have to be a U.S. citizen. You don't have to be a green card holder to write this letter. If you are in the pipeline of getting the green card, filing adjustment of status, you can write this letter. If you are going to file the 485 at a later date, please write the letters. They are created. Please pass these letters to the other people in the WhatsApp group and any groups that you have. Put them in the Facebook so that you have these letters written by every of your friend that feels that that these things need to be done. Emily, I want to discuss about the immigration consequences of being arrested. You know, we already presented the people that if you have a traffic ticket which doesn't involve any bodily injury and if it doesn't involve any arrest and you paid less than $500 as a fine, you don't have to mention the 485 application or N400 application. We clearly said that. But what if there is an arrest involved in either let's say, for example, DUI or maybe a shoplifting theft? What are the consequences? What do they need to do first?
Yeah, number one is whenever you're asked that question, have you ever been arrested, particularly on the I-485 application form, it does ask that. You will need to disclose the arrest, even if nothing ever came of it, even if you paid your fine and everything's over with, you still have to disclose it if you've actually been
Emily,
arrested.
my criminal lawyer told me that this case is expunged, that means completely closed, and that I don't have to disclose this information anywhere. Do I still need to disclose that in the immigration forms?
Yes, that's very important. So if you're going through that expungement process and you're also going through the immigration process, you need to make sure that you keep the documentation, because once it's expunged, the records won't exist anymore, but you do still have to provide documentation and disclose it to USCIS. Expungement everywhere except with USCIS.
Let's go through some of the common things when people get arrested, Emily. One of the common things that we normally see is DUI. When they get arrested in the DUI, what are the consequences for that, what you normally see on the non-immigrant visa and on the immigrant visa? Let's go to the non-immigrant visa. Let's say, for example, I have a H-1B stamping, which is still valid until 2023, and I got the DUI arrest. What are the consequences?
Yeah, most usually you will get a notification from the consulate saying that your valid H-1B visa stamp has been prudentially revoked. That doesn't mean that you are out of status. It doesn't mean you're going to be deported. This is just related to the visa stamp. Now, what does the visa stamp do? That's what gets you into the door of the United States. Once you're here, it's your I-94 that says how long you can stay. So just because your visa has been revoked, it has no impact right now on your status, but the next time you travel, you are going to have to get a new visa stamp, even if the other one has not expired. And as part of that process, if the DUI has happened within the last 5 years of when you're going for visa stamping, you're going to have to go for an extra medical exam to verify that there's no kind of alcoholism involved, and that could make you inadmissible. So that's the most important aspect there. So it doesn't put you out of status, it doesn't make you deportable if it's your run-of-the-mill, if there's a run-of-the-mill DUI, but your visa will likely be revoked and you'll have to go for stamping and go through an extra medical exam. And you do have to disclose that on your 485 as well as your DS-160 when you go for visa stamping.
Emily, I have a DUI arrest. You said that I'm going to get an email from the consulate. Maybe that email didn't came in. Maybe I didn't look into the email. Can I go outside the country and come back with a stamping?
I would not recommend traveling unless you intend to get a new stamp, because it's very possible that when you're coming back at the port of entry or even at the airport in your home country, they may not let you on that flight because they have the record of that revocation, even if you don't know.
Right, and don't rely on the information that your email might have been missed, maybe something might have missed. So if you have a DUI, consider that before you travel, you should not use the current visa that you have. Emily, the other thing that we sometimes look into is the shoplifting, though. What are the non-immigrant consequences for that thing, where the person has been arrested for shoplifting, and what are the consequences?
Right, so that doesn't seem to have, in most situations, your minor misdemeanor shoplifting does not have any impact on the visa or your current status, but it does have to be disclosed on the DS-160 as well as on the 485 application. When we were when we had the biometrics requirement for the I-539, which is typically used for H-4s and L-2s to extend their status, we were getting some requests for evidence from time to time saying, hey, we ran a security check based on the fingerprints you've done, and we see this shoplifting record from 5 years ago. Provide us the documentation to show what the current status is. So you may have to submit documentation to USCIS as part of an extension, but that we typically only saw when the biometrics requirement was there.
Emily, one of the other common thing that what I see is the domestic violence, though, which we know that it's a crime of moral turpitude. It has a lot of negative consequences if the person has been convicted, but there are sometimes, even if they are not convicted, there are some negative consequences, though. What should they do if by any chance they have been arrested for domestic violence issues, though?
Yeah, I think in addition to working with a criminal lawyer, you need to work with an immigration lawyer or work with someone who's familiar with the immigration consequences, because it needs to be determined what the ultimate charge is, what the ultimate conviction is, if there's any kind of discretion involved there, may change the outcome for how that impacts the immigration process. But the most important thing is you need to contact a qualified lawyer on both immigration and the criminal issue.
My criminal lawyer told that since the case is dismissed, I will not have any consequences. Is that right?
No, because you still have to disclose the arrest, assuming that there was an arrest involved. and any jail time was involved. You have to provide all of that documentation, both a 485 as well as the DS-160 process. And when you do disclose that on the 485 application, although they've been waiving some interviews for employment base, they won't waive the interview whenever there's a criminal background for someone.
Especially for the domestic violence, they're going to look into the arrest record very carefully to see what was being stated at the time when the person has been arrested. That is very crucial for the immigration lawyer, though. So when you consult an immigration lawyer, you should have the arrest. The police will give a record statement, written statement to you why you've been arrested. That is very important for you to give it to the immigration lawyer, because what I normally look into is that what did you made a statement? So irrespective of what happens in the court, the USCIS can adjudicate your application differently than what the judge has done in the criminal proceedings, though. The USCIS has a lot more discretion, especially when it comes to the domestic violence. I definitely, if there is any incident that there, I definitely want you to consult a qualified immigration lawyer. Question that comes out, how about the trespassing, though? Misdemeanor trespassing, will that have any impact on it? And the person has been arrested, Emily.
Yeah, generally they look at, is it a misdemeanor, and what is the sentence, the maximum sentence that could be imposed according to the state criminal law in the state where this occurred. So we can't say blanket, it's not going to have an issue. But generally you're looking at, it needs to be a misdemeanor, and it needs to be, the maximum sentence is less than 1 year of jail time. That may fall under what we call the petty offense exception, that does not make you inadmissible, to where you could potentially still adjust your status and still receive visa stamping after that. But it's very important to go through all of the documents with an immigration attorney as well as your criminal attorney.
Especially whenever there is an arrest, though, I strongly recommend that it's not only that you consult with a criminal lawyer, of course you need to, but you definitely need to consult with the immigration lawyer. If you're not a U.S. citizen, you definitely need to consult with an immigration lawyer to make sure what are the things, because every time when you fill a form, there are a lot of things, yes, no things, we normally fill it out. You may have to do it differently, though. You may have to look into very closely what you're filling, DS-160, the 485, sometimes on the H4 extensions also. We may have to look into those things, and you have to disclose this information to your immigration lawyer and get the proper guidance from it. Emily, it seems that there is a rumor flying around that especially this, the European ban that the Trump administration did on the travel ban is going to be lifted. There's a lot of rumor that flied out in the weekend. Didn't seem that it happened on the travel ban. Do you have any information about travel ban?
Yeah, no information, no legitimate, I guess, plans for them to do that. It seems to be rumors at this point, and this is all based on what's going on with COVID. They don't seem to care about vaccination rates in these countries, and it's a lot of political things between Americans being able to go to European countries as well, and if we're not able to go there, the reciprocity won't be there. So I'm not seeing these travel bans being lifted anytime soon. What are your thoughts?
It seems that there's a lot of pressure from the European Union to lift the travel ban. I am expecting maybe some better news. Even though we said until February nothing is going to happen, things may change, but at this point of time, I strongly request people to not plan anything until the things are very clear and it's been determined that the travel ban has been lifted. So don't plan anything until you have that. Let's go to question and answers that we have. Don't forget that we have drafted these 2 letters, one to the congressman to include the employment-based immigration. That is probably in the same lines of what these 37 congressmen written to the Nancy Pelosi, but we need you to write to your congressman, your senator, to be included in it. The draft is provided, and to try to prevent the 80,000 or 79,000 green cards that will be wasted this year, which ends on September 30th, we recommend that you strongly write a letter for that.
Jeet from YouTube wants to know, due to the travel restrictions that are in place, is CBP honoring the AVR process for travel to Canada or Mexico? AVR refers to automatic visa revalidation, and yes, you can still utilize automatic visa revalidation to travel to Canada or Mexico if your trip is less than 30 days and you have a valid I-94 at the time you're going to return. However, make sure you should travel by air for this because the land borders are still only restricted to essential travel. So you may not be able to travel by land, but by air it is possible. But you would require a negative COVID test to return back to the U.S.
Documentarily qualified. This question comes from Banu Prakash. That if my I-140 has been approved, would I be documentary qualified? Will USCIS assign the GC? This documentary qualified assigning the numbers have been taken a little bit out of context with regards to what Charlie has said in the visa department. Charlie has did in the department. With regards to the documentally qualified, what it requires is that the USCIS must have the I-140 approved. The final action date is current. The final action date is current. The medicals have been submitted. The biometrics have been completed. If all of those 4 things have been done, the officer reviews the file and then confirms and all these things are there, then it is determined that the person is documentally qualified. But normally, when you look into the practice of the USCIS, though, if the officer did everything and looks at all the file, he probably approves the green card at that point of time. We rarely see that they assign the number and they don't approve the green card. I mean, it's very rare that we see that. I mean, that when the priority date backlogs, they're going to approve the green card at a later date. We don't see that, Bano, that much. In my experience, very rarely we see. So until the green card is approved, according to me, they have not assigned the number for you.
Questions on the H4 and EAD premium processing option. It's still not an option. This is something that was passed by Congress over a year ago now. But USCIS does seem to be in the process. We do have that in the regulatory agenda that they're planning to create premium processing for H4s and EADs. At the same time, we have very long processing times for the H4s and EADs, and so it's very possible that they might try to improve those processing times of pending cases first before they implement premium processing. Otherwise, it looks to the public like they purposely slowed down the process so that they could generate money through these premium processing fees. So we may have to wait until they get a handle on normal processing times, bring those back to maybe 6 months, and then have the premium implemented.
Lakshmi is asking, where can we find the draft of the letter? It's there in the link provided in the Facebook. If you go bottom, the content of it, the things were being provided, and also in the YouTube, also things were being provided though. Tulsi Das Ram Reddy from YouTube has this question: can the Indian Embassy provide birth certificate for the green card? No. It should come from the municipality, or it should come from the place where you're born at, not from the consulate. Consulate normally looks into the document and says, based on the document, here is what is said. But that is not a reliable proof. If we have put some links with regards to the birth certificate videos, and also a link of the draft of the affidavits. If you can't get the birth certificate, it's provided at the bottom of, it's there in the link at the bottom. So please scroll down in the content of it at the bottom. You will find those links, Mr. Tulsidas.
Damnita Singh wants to know, is there any grace period when switching from L1 to H1? This is a very common question that comes up this time of year with CAP subject H-1Bs taking place October 1st. There is no grace period. So if your change of status from L1 to H1 gets approved after October 1st, it takes effect immediately. That means USCIS expects you to immediately stop working for your L1 employer and start working for the H1 employer, assuming that the H1 was filed by a different employer. I often recommend L1 employees who are in that situation to request consular processing of the H1 so that when they're ready to actually make the switch to H1, they can activate the H1B approval by either going for visa stamping or having the same employer file a change of status at that time, because there is no grace period.
Someone has this question: after approving the 485, how many days do we need to stick with the employer? Or you can leave the next day. Now, this has been a very controversial statement. A lot of people are going to a lot of forums, and these forums are telling it's 6 months, 180 days. There's nothing like that. In fact, the law provides that you can leave the employer and go join another employer before even you get the green card too. So imagine if you can leave it before you get the green card, you can leave it afterwards too. You can. Now, if you leave before you get the green card, when you join another company, we recommend to file a 485J supplement, and then you must be working in a similar profession. There are certain things that you need to comply with. But after you get the green card though, I mean, you can flip a burger in a McDonald's, you can be a Microsoft CEO, or you can be a lawyer like me, or you can just sit down and do nothing. Those are all 4 options that are allowed. The only thing that I can think that you cannot do is probably be a drug dealer. Definitely not. Weed dealer, even though the weed may be legal in some of the states, no. And a green card holder, you cannot be doing that thing. Absolutely you cannot. But you can flip a burger, be a Microsoft CEO, be a lawyer like me, or you can just sit and do nothing.
Mangesh says, is AOS a status itself? The H4 visa is expiring, and I'm wondering if I need to file an extension. So, being very technical here, AOS is technically not a status, but it is lawful presence. So when you're in adjustment of status and your underlying non-immigrant visa status expires, normally when you overstay an I-94, that's unlawful presence. Here, there is no unlawful presence because you have a pending adjustment of status. So you are lawfully present, you can stay in the country, even if you did not file the H4 extension. It's your choice whether to continue the H1 and H4 or L1 and L2 status if you still have more time left towards your 6-year limit, or because once your priority date is current, if you're beyond the 6-year limit, you can only get a 1-year extension anyways. But you do have that option, and there's no mandatory requirement for you to continue your H4 status after your adjustment of status has been filed.
Question, Ralapa Srini, what does concurrent filing means? Well, especially when it comes to the employment base though, the word concurrent filing we normally mean, for the green card purposes though, what we mean is to file an I-140 and 485 together. That's the word we normally use. There is nothing officially in the law that says it's a concurrent filing. We are allowed to file an I-140 and 485 at the same time if the priority date is current. Now, obviously, when we file the 485, we have an option of adding the I-131, which is an advanced parole, and also the I-765, which is an EAD. We can file 485, advanced parole, EAD, and I-140 at the same time. But typically the word concurrent we mean, and a lot of other people mean, I-140 and 485. In the family immigration, what does that mean? We mean is I-130 and I-485. These are when you combine both the things, we call that as a concurrent filing in the immigrant visa.
Suresh is on H-1B with a max out date coming in March, and for his I-140 processing, he's being asked to provide his original degree certificate, but he only has a provisional certificate. He wants to know what are the chances of the I-140 approval. I don't see any problem with going ahead and filing the I-140 using the provisional certificate and all of your mark sheets or transcripts. There's a chance USCIS may come back and ask for the actual degree certificate, but there's a good chance they won't. It's not necessarily mandatory in all cases for you to provide that.
Prad from YouTube, he received the green card last month, congrats. Does travel ban applies to the GC holders? No, it does not apply to GC holders. You can travel, you are fine. Raj Kumar from YouTube has this question. Birthplace name changed. Can we use the page link, record name change in the Google? Rajkumar, I normally won't do anything unless the RFA comes in, because sometimes they overlook, they get confused when they see this website. Why are you giving the website kind of thing? So yeah, the Chennai, Madras has been changed to Chennai, Bombay has been changed to Mumbai, and states names also have changed from Andhra Pradesh to Telangana. In India particularly, there are a lot of changes that occurred. A lot of other states' names have changed. That's fine. I would not include anything. I would just submit the birth certificate and all the documents, and if and when they will ask any RFE, then I will submit them at that point of time. That is the strategic thing that what I would do. But if some lawyer says that he would like to submit all the details, I'm not telling he's wrong. This is a strategy I use. It doesn't mean that the other lawyer is wrong.
Ashok has a 485 pending and the final action date is current. His case was in the field office in Sacramento, but now it seems to have moved back to the National Benefit Center, the MSC receipt number. Why is it back at NBC? Most likely this is because they've chosen to waive the interview requirement and they've transferred it back for the approval process. Yes, the field office can also approve the application without the interview process, but it may actually be faster for the National Benefits Center to do that.
Question from Satish from Facebook is, when can we get more details on budget bill? We're expecting that on September 15th is when we'll get a little bit more better version of what we already got right now. That's the reason it's important that you write the letters to the congressmen in the interim period, though, from now on to September 15th to get more details, though. Karthik Dinadayar from YouTube has this question. Is anything going to change in the employment-based green card? Is it same old story, bills not getting passed in the final level? You may be true, Karthik, but this is a marathon. This is not a 100-meter run. I, in particularly, know the pains of being a marathon. I've run 20 marathons, and continuously for 13 years I've been running a marathon. So in the marathon race, what you do is that you have to keep on going on steadily. This is not 100 meters, this is not a dash. It's a long run for you. You have to keep struggling. You have to keep writing letters. Look at how the Dreamers have done. I mean, they have been struggled. There are senators who cried on the floor of the Senate, still couldn't get anything done, but eventually Obama administration has given them. So yes, it is going to be a long struggle. You are here on the YouTube, writing a letter is definitely plays a role. I mean, we have seen some improvements with regards to how the USCIS has reacted to your letters, where they have done a little bit better job than wasting 100,000 plus green cards that we were expecting. They have issued RFEs, very many RFEs on the medicals. They have issued notice of intent to deny. They have issued emails, text calls from the USCIS for you to submit the medicals. There are a lot of other steps that they have done. They've extended the period of the medicals for a longer period of time. So there are a lot of different steps that were being achieved. Yes, did we achieve the final goal? Did we hit the final goal? Did we got the Gold Cup? Did we got the FIFA World Cup? No, we didn't. We should keep trying it. I mean, we should keep trying it. There are some interim benefits that will get it, but if you don't do it, and you and other people don't do it, then nothing is going to be achieved. We need to. We have been struggling about this one every single day in our office. We try to see what we can do. Can we go to the court system? In fact, we had a 45 minutes conference call with the Washington, D.C. lawyers pounding on these things. Can we go to the court? We have seen what happened last week. We didn't get the actual final results. That doesn't look like that may be winning case. So the best step when we don't have a legal source is to go politically. That's the reason why we draft letters for you to keep writing. And Emily, can you want to update that? What can we do for these people who's waiting? They're wasting the green cards out there. Can we not go to the court? And what's the solution for it?
Yeah, that is a really difficult task because in the adjustment of status realm of the law, courts are very hesitant to say they have jurisdiction to tell USCIS when to adjudicate someone's I-485 application. So they will say that they don't have it has to be an unreasonable delay, and they are hesitant to say almost any delay is unreasonable because the agency has deference. They have to be able to move their resources and use their resources as they see fit, and the agency keeps saying it's COVID that's messing everything up and we just don't have the resources. They can't just go out and hire more officers. So even if you bring a lawsuit challenging a 485 delay, it is very unlikely to be successful. They will try to move the case from one court to another. They'll try to just get the case dismissed, and then the judge is not likely to side with the applicant on that front. We have been heavily researching that. That's what we've been seeing in prior cases that have been filed, even the one that had the hearing just last week. It seems clear that they want to separate out all of those cases that were combined together, move them to different courts, and then let the individual judges decide whether the delay is unreasonable, and usually it's not.
Yeah, the question comes from Hari Kiran Juneja. Can I drive to Canada and return on US in 2 weeks on a H-1B and H-4 visa? For sure, if you have a visa, you definitely can come back to USA. I believe there is a restriction on driving, though, for sure. But with regards to flying to Canada and coming back, there is definitely no restriction. But if you are driving back, there is a restriction. Only essential workers can come on the road. I don't know if that has been changed recently, but that's the latest knowledge that I have with regards to Canada and Mexico.
Mohammed has received an RFE for the medicals for the principal applicant, but not the dependent, and wants to know how should the dependent proceed. I would recommend going ahead and getting all of the medicals done, maybe get extra copies for the dependents, as we've talked about before, and go ahead and send the dependents in with the principal applicant's RFE response. You can try to also do an interfile and then hang on to a third copy in the event that they do end up getting an RFE.
And the question is popping up, and I need your assistance in that. You are the data queen in this, and I don't know if you're going to publish anything on your immigration girl, because I know that you've been collecting the data with regards to the green cards. Amounts of green cards have been filed, which service center, and if it starts with M, if it starts with L, if it starts with S. S is for Texas, L is for Nebraska, M is for the National Benefit Center. Can you throw a light on the green cards that were filed and approved in these respective centers?
Yeah, so I've been looking at all of the cases we filed since October, during the October, November, December visa bulletin. And of the approvals that we've been getting since about May, not one came from Texas. One came from Nebraska, but that was a case that was filed in 2012. Every single approval that we've received from cases that were filed last October all came from the National Benefit Center. Texas is not processing them. They're very slow. I mean, part of the problem is all of the downgrades with the concurrent 485 filing went to Texas. The downgrades are taking forever. The only way that seems to be able to get those approved is to upgrade to premium processing. So Texas definitely is way behind on their processing, and we are looking into those downgrade delays as a litigation option there. So yeah, the data does not look good for Texas cases. If it's at the National Benefit Center, they are approving those, and based on the declaration that came out from one of the lawsuits, it seems like USCIS is planning to approve about 30,000 more green cards between now and September 30th for employment-based. So they definitely are approving a lot, but they're still, even with that, they're still going to waste at least 80,000.
Not within the office assembly, outside the office I had a consultation where there are some very rarely green cards that were approved in the Texas, though, very rare though. But yeah, your data seems to be that very bad. And a lot of people are asking the question, should we refile it? What can we do about it? Let's say, for example, if their priority date is July of 2011, should they just refile the entire application because they filed the downgrade application?
With the refile it in EB2?
Yeah, EB2.
Gosh, that's a hard one. At this point, I think our stance is still it's not worth refiling, given that it's going to put you at the back of the line. At least now you're almost a year in, and you should be getting the green card within the next 12 months, I would expect, because USCIS, again, in their declaration said they have enough green cards available in fiscal year 2022 to get through all of the pending 485s. So yeah, I don't think I would refile. You're just going to be behind everybody else.
I agree with you, Emily. Mr. Sridharan has this question. Is there a premium processing for 485? No. If there is a premium processing, believe me, buddy, all my clients, all the people here would be out. And I wish there was, but there's no premium processing for it. Rala Pasrini has this a very good question. Where can we control where we file the application, though? Right now, there are 3 places where we can file. One is Chicago, one is Phoenix, and one is Texas. It depends on where you live. You will have to file in that particular place, though. However, though, when you're filing an I-140 and 485 together in the normal processing, though, it will only go to Louisville, Texas, only Texas, no other place. So a lot of people, what we recommended previously about 2-3 months ago is keep the options open. I mean, if you are EB2, file an EB3, get an I-140. Now, in that case, though, where the I-140 was been already filed under EB3, where people have both EB2 and EB3, yeah, it depends on where they live. They can file the application based on that. But if the I-140 and 485 has to be filed together, there is only one address if you're filing in the normal. That is Texas, no other address.
Rajiv is currently on his STEM extension and also has an H-1B petition with a change of status that's approved for October 1st. And he wants to know any issues with traveling before October 1st. So there's differing opinions on this, and the reason is the last action rule and how that impacts people who have traveled after the change of status has approved, but before it takes effect. There is an old memo that's, I think, over 10 years old now, specifically for F1, that says if you travel after your change of status is approved, but before it takes effect, you can do that without abandoning your change of status. And the last action becomes the change of status taking effect on October 1st. That memo is very old. The main issue people have often is driver's license renewals, because that refers, it's all connected through this SAVE system. So you may have difficulty with that, but as far as the status being an issue, that memo seems to be still good law, still reliable. But yes, you do have to prove your non-immigrant intent when you are coming back on the F1 because it is a non-immigrant intent visa.
Annie has this comment from YouTube. Indians don't get enough support from the other Indian origin people who have already gotten their green card. I kind of agree with you on this, Annie. Here is the reason. When I go to my circle, my age circle, you know, we immigrated a long time ago. Of course, I am knowledgeable because of, you know, why I'm knowledgeable. But when I speak with these people, my age own group people, they don't understand immigration at all. In fact, they're like, what? It takes 10 years to get the green card? They don't understand. They lost the entire thing. They got the green cards. They applied their citizenship, which they didn't use an immigration lawyer to do it, and which, you know, I mean, it's a pretty easy step. A lot of people do by their own. But they forgot that they think that green card is only within 3 years, or some of them got the green card 1.5 to 2 years. They don't understand. They definitely don't understand. Now, how do we make them act is very important, Annie, because we need to use them too. What they invite you is to come to these cultural organizations and all these different functions. They want the numbers to see. They want all of you guys, the H1s, OPTs, student visa people to present there, to go there. But they don't want to give a support with regards to green card letter. So what I suggest is that when you go to those things, form a group before you go. You know, we are 30 people, we want to come in, but we want to put a booth where we will have a computers there. We will have these people coming in. They have to go through our booth, and this, since it's a non-profit motive, they should give you a booth, and you should tell them that each of the person, we should at least have them write a letter to the congressman before they go. Have a couple of iPads or a couple of laptops, provide them, and have them write the letters. They will definitely. The main thing is that they don't understand. They don't understand, and because they lost the touch of the green card. They are U.S. citizens. They have been green card for a long period. They forgot the whole touch. You need to explain to them, and then when they come into these associations, you have to make them write the letters then and there itself. That's the only thing that I can think. You know, when I tell these leaders that, okay, this, you need to do it, they don't care, because you guys are going, you don't ask the question. On the other side, oh, you are going to benefit because of these advertisement that you get. That's the reason why you're doing it. Why should we give you a booth? Why should we allow you to do all these things? You should pay for it. You need to do all those things. And they tell me all kind of bad things. So, but if you as a group, I bet though, as a 40 or 50 people, look, I'm going to come to this association meeting, but we need these things to be provided for it. This is the thing that is affecting us. This is the thing that is affecting our productivity. This is the things that every time we go outside the country, we have to get the stamping. Sometimes H1B extension gets delayed, delayed. H4 EADs get delayed, denied. We need these things to be done. If you make an effort though, I bet they will act. But if I go and tell them, they just ignore me. So if as a group you go, hey, you know, the movie star is coming, you guys are going thousands and thousands, but you don't demand what is happening. You need to, even if the movie star comes in, you need to demand them, look, movie star, we need this thing to be addressed. You have influenced the people who have got the green card previously. You need to address this issue. So you need to make that as a rule whenever you go to any cultural association or any language association, that you will have them advocate. And if they don't advocate, we take them as racist and walk off from those associations.
GR Surya from YouTube submitted an EB3 downgrade 16 days ago and still no receipt notice. Is that normal, or do I have to wait for more time? I would say these days it's a little longer than usual. We're usually getting them within a week or two. There's not really much you can do until it's been at least 30 days, and then only your employer can follow up with USCIS if they have not received a receipt or a rejection after 30 days.
Question from Fawad Khan. Is it okay to move to a different company after filing, after more than 6 months? The question is not clear whether the final action date is current or not. Let me tell you the answer, Mr. Fawad. It doesn't matter if the final action date is current or not. After filing the 485, and it's been more than 180 days that the 485 has been pending, you can move to a different company though. We normally recommend strongly to file a 485J supplement, but with regards to if the prior date is current or not, it doesn't matter. But one thing, Fawad, though, I strongly recommend is that make sure your I-140 has been approved. There are some exceptions available. I don't want you to go into there, but I just want to make sure your I-140 has been approved. A lot of people ask the question, is it required that the I-140 be approved for more than 180 days before you move to a different company? No. As soon as the I-140 is approved, you can move. The only rule is that the 485 has to be pending for more than 6 months.
A couple of people are asking about is USCIS policy doing things in, first out. They see other people getting their approvals even though they filed later. You know, is it based on priority date? How are they determining who gets adjudicated first? There are a lot of moving parts here, so it's not just based on your filing date, the day you filed your 485. It's also based on is your final action date current, and is your I-140 approved? Is your medical exam there? Have your biometrics been done? If all of those things are true, then it just depends on which officer's desk your application lands on and how fast that officer is compared to other officers in other service centers. So it's not just first in, first out.
Questions with regards to the H4 and EAD premium processing. At this point of time, we don't have any new news with regards to the premium processing of the H4 and EAD.
IAPEN wants to know, can a dependent use the green card EAD and then later get back to an H4 EAD after it gets approved? While they can use the green card EAD, it's not a simple process of getting back to H4 once you've used the green card EAD. Once you use that EAD, you're no longer in your non-immigrant status, and you don't move back into the non-immigrant status just because the H4 EAD have been approved. You actually would have to exit, get the visa stamped, and come back and make sure that you're not abandoning your 485 throughout that process. So it's not an easy thing to get back to your H4 status after using the green card EAD.
Mr. Sridharan has this. His prior date is May 2012. They applied for the PERM. Can he apply for the I-140, I-485 together? Assuming that you're thinking about it's an EB3, which is current actually. Yeah, you can. Can you apply in premium processing for the I-140 when you're filing concurrently? Yes, you can. This is only if your labor certification has been approved for less than 6 months. It's okay to apply in premium processing. Though we had some hesitations previously on that, now we have tested it many times. It's working perfectly. Now this is only if you are using the PERM that's been approved within 6 months though. If you're using the old PERM, which you are downgrading it to file an EB3, we strongly recommend do not file in premium processing. And you get another advantage though, Sridharan, that if you file in premium processing, though, there are 2 addresses. So you may fall into address that is not Texas. So that is an advantage if you file in premium processing.
GP has an H4 that has not been approved. Even after waiting 14 months, it's actually past the normal processing time. Tried a service request and no use. What should I do if there's no response to that e-request? Your next step is to reach out to the Ombudsman office. There's a form that you can fill out electronically. It's the DHS 7001 form. You do have to provide the information showing that you tried the service request first, provide the date of that, the confirmation number, and that you've not received a proper response, and then they will look into the case on your behalf. It takes a couple of weeks for them to get around to looking into it, but that usually is your next step.
Questions with regards to the biometrics though. We get a lot of calls with regards to the biometrics. My spouse got it, I did not get it. My suggestion to that person is take your spouse along with you. Make sure the 485 receipt notice is with you and you take it. That's a suggestion that I would do. People who have changed the address and they got the biometrics in the old address, some of their lawyers are suggesting to request the change of address. My recommendation is no. Don't do that, because it's going to take ever. If you have to drive from Florida to California, drive it. If I were you, I will drive all the way, because I'm not going to postpone it, because God knows when I'm going to get it, if I'm going to get the biometrics, when I am alive. The good news that we got from the USCIS recently is that they are going to reuse the biometrics. If you have done the biometrics previously though, they haven't given very clear indication in their declaration to the court. What do they mean by reusing it? Definitely it seems that if a person has applied a H4 visa in United States after 2019, after March of 2019, they have given the biometrics, that is going to be used. Does it mean that the people who have given biometrics at the consulate, when they got their visa, will they use those biometrics? We are not sure about that. We are not sure, but at this point of time, it looks only the H4 visa people that got given biometrics will be they will be reusing for at least some people, not all, but at least some people.
AVE wants to know, my I-140 had an A number assigned to it, but my wife's I-140 does not have one, even though they're both approved. Is this a cause for concern, and what is the reason for this? No cause for concern. We do see that from time to time. I would say the majority of I-140 approvals do have an A number assigned, but we do see from time to time some approvals come through without an A number. Nothing to be concerned about. No idea why it's like that, but don't worry about it.
Giriraj from Facebook has this question. What if somebody switches from L1B to L1A and L1A gets rejected? What happens to the L1B, existing L1B? Nothing happens. You can continue working on L1B. It's not rejected, it's not revoked, so you are good to continue working on the L1B.
Lakshman wants to know, do we have any idea why these downgrade applications are not being adjudicated and just piling up even though they're ready to approve? I think it's resources is a main issue when every single downgrade plus the I-485 that were filed last October, November, December, they all went to the same service center. They just don't have the resources. They do, as of right now, they re-adjudicate the whole petition for no reason I can come up with. They pull out the old labor certification from your old file or get it from the Labor Department. All of these things are taking time, they are wasting time. But we're looking into that. We're looking into the possibility of doing a Freedom of Information Act requests and possible litigation to figure out why they have the process the way they do to push them to be more efficient about it. There's no reason for them to re-adjudicate it. The entire application is 99.999% the same. The only difference is you check one box different. That's the only difference between EB2 and EB3 on the I-140 petition.
I disagree with Emily with regards to the resources. I think so. They just should fire the Texas Service Center director. That's it. I mean, you're fired 3 months from now because you didn't do the job. Believe me, all these things will get adjudicated within 3 months. They've been allocated overtime. They've been allocated a lot of different things, though. That's the best step that I would recommend is to fire these people. That's the only thing. Fire them. And don't fire them immediately, though. Do fire them, like give them. You're fired 3 months from now because you didn't act properly. Believe me, by 15 days, all of these things are out and they will be adjudicated, though. A lot of things, what they have created, these extra hurdles, the administration, especially the Trump administration, has created an I-944 form. Man, oh man, that was such a long form, giving even 2-year-old kid has to, we have to give details of the credit report. Where am I going to get the credit report? The card doesn't even have the social security number. Assets of the 2-year-old kid, really? They have the assets? I don't know. But anyway, we have provided all that information. It took a long time. It took almost 4 to 5 months for them to issue receipt notices. They have created this thing called interview for 485 for the employment wage, which was not there. Starting from March of March of 2017, they started this. These are all the extra steps that they have done to hamper the opportunity. Now, Emily has said that it's 99.9% the same thing. It's just like they say, every billionaire is a millionaire. I mean, we all know that. Very surprisingly, somebody who's a billionaire will not be a millionaire. That's exactly what we're doing in the EB3 application, but they're still re-adjudicating. Now, they are telling that it takes a long time for them to pull the labor certification. Guess what? When we file the Freedom of Information, it takes only 3 weeks for them to pull it out. Why is it from their own website? It's not from outside website. Why is it taking such long time for them? Why can't they believe that labor certification, all your lawyers who file the labor certification, they have included that labor certification in there. They have seen the original labor certification. And if there is any fraud that happens, yeah, you can go after the lawyers, you can go after the employers, you can go after the employees and revoke the whole green card if the labor certification has been faked. So why are they just not approving in the premium processing? Why are they not accepting? These are the steps that could be avoided. The only way that I think so is these people need to be fired, and they should be fired starting, given them, you're fired from 3 months from now or 6 months from now. That's it. Everything will be acted properly. You can't do the job, resign. Okay? There'll be somebody else who are willing to do. There are 996 other people who are willing to do the job. You can't do the job, resign, get out.
All right, well, I think we're out of time for today. Thank you so much for joining us. Please remember to subscribe if you're watching us on YouTube or on Facebook so that you get notifications of our upcoming videos, and also subscribe to our newsletter by going to rnlawgroup.com.
And don't forget to write the letter to the Congressman and the US CIS Ombudsman.